We are closed to the public currently, so we are doing everything remotely, including our oral arguments. But again, thanks so much for joining us. And I'm so happy to introduce to you one of our justices. So Justice Alan Lawson is actually a Florida State College of Law alumnus. And he joined the court in 2016. He is in his office in Orlando currently, but he is calling into us today and is happy to answer your questions after he discusses the operations of the Florida Supreme Court. So with that, I would like to introduce you to Justice Alan Lawson.
Hey, it's great to be with you virtually. I've enjoyed doing this for the years that I've been on the court in person and missed that, of course, this year. I decided at the last minute, put on my robe and decided to change my background so that you could see as a participant what it looks like now in our virtual oral arguments that we've done for the first time now for 2 months. The first one was May, and our tech people got the background of the courtroom for use behind us. So this is what it looks like when we're doing virtual oral arguments now. We have a summer recess period where we continue to work on cases, but don't have oral argument. So after our June oral arguments, we don't have more oral arguments again until the end of August or the beginning of September. I'm not sure which it is this year, and hopefully we'll be back live. But enough of that. I want to just introduce you to the court and then predominantly answer your questions. So I've been on the court. I'm in my 4th year now, and as Emily said, I'm an FSU law grad. In our 7-member court, 2 of us were in the same law school class at Florida State University. So my good friend and colleague Ricky Polston and I studied for evidence together and a lot of other classes, and now it's a pleasure to work with him at the court. But I want to just, you probably know a little about the Florida court system, maybe nothing about the Florida court system. Every state is different, but of course all states have trial courts, courts of original jurisdiction for most actions, and appellate courts that handle appeals. And our common law system, which is rare in the world today, appellate courts have a really, really unique role. And most of the public think that we are in court a lot. We take testimony, we take evidence, we decide facts. And of course, as you probably know, thinking about law school, in the common law system, everything is set at the trial court. The trial court, the finder of fact, determines what the facts are, and we're not going to disturb those. Even if you read a record and think, I don't think I would have believed that person, as long as there's competent, substantial evidence in a record to support a finding by the trier of fact, then that's it for appeal purposes. So what we do is really just issues of law, and that's very different in a civil law system. At each tier, you have an opportunity to sort of retry the case, try a different theory, put in new evidence and that kind of thing, and that's just not part of our system. We put so much energy, time, and effort into giving folks their day in court in front of a jury. We bring citizens in. That's unique in the world too. And because we do that, and they generally are the trier of fact and finder of fact for most things, you just can't replicate that in an appellate system and the common law system. So on the decisional side, what we are doing is mostly reading, research, and writing. And only a small fraction of our cases have oral argument. We handle about, the last time I checked, 2,700 cases a year, and we'll have well less than 100 that have oral argument, probably closer to 40 or 50 during a year that have oral argument. So we spend very little time in the courtroom compared to the amount of work that we do outside the courtroom. And as I said, most everything is research, reading, and writing. We also meet in person. And when we have a smaller group, and sometimes with this bigger group too, right behind, we go out a door behind those chairs that you see behind me, there is the conference room. And we sit there and talk about cases and conference cases that don't have oral argument and that do have oral argument. So that's where we make an initial decision on a case, and then we separate and go about our ways, and the case is assigned to write on And so you constantly are getting ready for talking about another case, deciding another case, and working on the case that you already talked about in conference to write the opinion. And then it takes a fair amount of energy, time, and effort to get the opinions done and the cases decided even after we talk about it and come to a preliminary resolution. But that's really only half of what we do in the state court system, because the Supreme Court is in charge of the legal system in Florida. So if you ultimately want to become a lawyer in Florida, you will sit for an examination and you'll have a character and fitness review that is done and administered by the Florida Board of Bar Examiners, and that's an entity created by the Supreme Court. And so all of their policies, from the most basic things to what's the score that you have to get on the bar exam to be admitted in Florida, is a decision that's made by the Florida Supreme Court. We take advice from the Board of Bar Examiners. We select those people to sit on the board, and then we do delegate some decisions, policy decisions, to them, but the big ones we make. And then regulation of lawyers. In Florida, we have an integrated bar, and so if you're a lawyer in Florida, you're regulated by the Florida Bar. But all of those, that organization is created by the Board of Governors. The whole system that we have for the Florida Bar is created by the Florida Supreme Court, and all of their policy decisions, we delegate a lot to them, but the big ones, again, come to us. And then we do the same thing with the state court system. The way Florida, we have 2 levels of trial courts, county courts and circuit courts, and the legislature budgets for the entire state court system one lump sum to the trial courts. And then we've established a trial court budget commission that takes that money and figures out where it needs to go so that we can evenly supply justice. Okay, so Emily's just given you a chart here, and you can see what our court system looks like. And so we have the county courts at the bottom that handle lower value civil cases and handle misdemeanors where the max penalty is 1 year in the county jail. And then everything else is the circuit courts. They're the courts of general jurisdiction. And then we have the district courts of appeal, and that there are plenty of states that have one tier of appeal court. And because of the size of Florida, many years ago, the caseload just got too big. And so Florida established initially 3 district courts of appeal. It's been expanded to 5. But those are the courts of general appeal from now everything else below them in Florida. So you have one appeal as of right, and that generally goes to the, and there you can see the districts where they are. The 3rd District Court of Appeal down in the very southern part of the state, 4th District on the eastern part of the state in the south, and then the 2nd, 5th, and then the 1st in North Florida. The 1st also has some unique things, like it gets workers' compensation appeals from everywhere in the state, so it's unique in that regard. And it tends to get a lot more administrative appeals because that's where most state agencies are housed. But then to get to us, we're a court of limited jurisdiction in terms of the decisions that we make. And so we generally will only hear cases if there's a conflict in the law between a district court of appeal. That's how we get most of our cases. If somebody says the 3rd District handled this issue and they said the answer is A, the 5th District handled it, they said it's B, then it comes to us. Or if a statute's declared unconstitutional, we take it. If the district court certifies an issue as one of great public importance, then we get it. So we get very few cases. Our original jurisdiction from the trial courts, we have 2 areas. If the death penalty is imposed, let's see, that's there, okay. Death penalty is imposed, then that goes straight to us and bypasses the district courts of appeals. So we have original appeals in death penalty cases and bond validation cases. And then unless a statute's declared unconstitutional, that top one, we can take a case if the lower appellate court passes on the constitutionality of the statute. If they declare it unconstitutional, we have to take it. And then the public utility cases, we get those from the statewide Public Utilities Service Commission. So that's where we get our cases. It is a very big and very time-consuming job, and it involves a lot of travel around the state, or it used to before COVID. It hasn't now. Now it involves a lot of Zoom meetings. I was on one with the board earlier today, one yesterday with the Trial Court Budget Commission, and so each of us have liaison roles with the various commissions. It's a privilege to serve in this capacity, and I'm going to stop talking and let you ask any questions that you have, and then when you're done with that, we'll turn it over to Emily for the tour. So, any questions?
Can you tell us about the steps that you took to become a judge, and if it's different than Florida, or do all judges have to go to that same step? And how did it look like after law school? Did you know you wanted to be a judge right after law school, or was it through after you started practicing? Sorry, I didn't know if we're supposed to write down or ask out loud. That's
a great question. I'll talk about the system, and every state. I mean, there are only so many ways you can become a judge, but that's set by state law for state court judges. So in Florida, our trial judges, so county and circuit court, are elected positions. So if you're a trial court judge, anybody can run if there's an opening. A lot of judges get appointed, though, because if there's under the Florida Constitution, if there's a vacancy before the end of a term, then the governor appoints, and then that person is up for re-election at the first general election after one full year in office. So you get, if you're like anybody who's appointed earlier this year as a trial court judge in Florida, because they won't have a full year when November comes around for the election, they'll get a 3-year initial term because they won't go on the ballot again until 2 years from now. So I was initially appointed in the Ninth Circuit as a trial judge, which is Central Florida, Orlando area, and which is where we live. So I was appointed as a trial judge, and then was reelected without opposition. Nobody ran against me. So that's how it is with trial judges. With appellate judges in Florida, you only get the job by appointment. No one can run against you. And so I was appointed as a 5th District Court of Appeal judge. I was there I served on the trial bench for 4 years, 11 years on the District Court of Appeal. I was a chief judge there when I got appointed almost 4 years ago to the Supreme Court. But we have a system called merit retention, which some other states have as well. So the same deal, the first general election after one full year in the office, your term is going to expire and you go on the ballot and people can vote yes or no. So nobody can run against you, but folks could, in theory, vote you out. That has happened in some states where appellate judges have been voted out of office. It has never happened in Florida. And I've been through a lot of retention elections as a DCA judge, only one now on the Supreme Court. I was the only Supreme Court justice up and got retained. And then we have 6-year terms. So after retention, I would go on the ballot again 4 more years from now because I was on the ballot in 2018. And then to the last part of your question, I did not know that I wanted to be a judge when I graduated from law school. I wanted to be a litigator and did that for 15 years. And I really just, it was a combination of things, but I thought that public service, the more I watched the judicial system work, the more I was in court trying cases and handling cases in front of judges, the more I thought, I really believe I could do that and it would be a phenomenal service and I think I would really, really enjoy it. And so I was, at the time, had a good friend who was applying for appointment when the vacancies was come up in Orlando, and I'm not going to compete against him. So I didn't, and then he moved. He got a job in DC. It was somebody that I worked with. And the next one that came up, I applied and was fortunate enough to get appointed. And then the positions after that, I didn't think I wanted to be an appellate court judge because all the excitement and energy is in the trial courts. I mean, that's where the drama really happens. And you're engaging with lawyers every single day in court. And I thought how boring it would be to do the appellate work where it's all research, reading, and writing. And after a few years, I sort of changed my view of that. I really love the law, and I really do enjoy writing, and decided that eventually I'd want to be an appellate court judge. And it's different now in the electronic age. And I applied in the electronic age and was an appellate court judge. In the old days, when you're dealing with paper and there are emergencies, which there are at any level of court, you had to be where the paper was. So an appellate court judge meant that you were driving to the courthouse where they would bring, the cases to your office every day, and it would go from your office to the other judge on the panel to the other judge, and you decide things, and emergencies could come in, so you had to be there to look at the paper. In the electronic age, it's a really incredible, it's as I said, it's a very demanding job, but you literally can do it from anywhere most of the time, because we use Westlaw to research, of course. All of our documents that we look at are online, and so everything is online. So we, except for the times we're in court and conferencing, we really can work from anywhere. And that was part of the appeal for me. But I really have enjoyed it. And I would say, in terms of how you get there, it's just really like anything else. I mean, you pursue and excel at what you're doing at this stage of your life, and give your best to that, and become the best you can be at what you're doing, and that will be recognized. And then if you find something else you're interested in or want to do, all the people who've watched you perform, who you've gotten to know, who you've become friends with, are really going to rally. It's been an amazing process each time I've applied for something, that folks that I tried cases against, so on the other side of cases, would like write letters to the governor saying, you should appoint him, he's a phenomenal lawyer. Because so you deal with people the way you'd like to be dealt with, you act with excellence and integrity, and then that opens doors for other things. So that would be the answer to your latter part of the question. Anything else?
Yes.
We've had some questions in the chat. I'm sorry. During this phase of online cases and oral argument, are you implementing a virtual jury to hear the case as well?
So what we've done is by administrative order, the Chief Justice set forth a task force to figure out how to handle cases in a COVID environment. And that task force has been giving recommendations that the Chief Justice has been implementing. And one of those is to try a virtual jury trial. I mean, so we have 3 of our 20 circuits in Florida that have been authorized to try that. And there are concerns about that from a confrontation clause standpoint and that kind of thing. So what we've done initially is, I think the first opportunity for a virtual trial was last week in Orange County, and we decided to say, are there volunteers? Anybody willing to go? And nobody volunteered. So there wasn't one. So I don't know where that will go, but we are certainly looking at it, and we have pilots around the state to do it. I don't know if we'll get to the point where we say, okay, you're going to trial, and it's now, and it's going to be virtual. The lawyers, and you can imagine, trial lawyers just are like everybody else. We're all afraid of the unknown, but if you've tried a case in front of a jury and you've been there and you've watched them in the room and that kind of thing, the thought of doing it electronically is just something that people are not excited about. They're also not excited about having jurors in masks and not being able to see their expressions, and feeling like if you have to wear a mask that you really can't communicate as effectively to the jury as you want to. So there's a lot of fear about that. But we've got to figure out how to get jury trials going. For 4 years I handled felony divisions in Orange County, and we have had a very busy felony docket. I would resolve about 2,000 felony cases a year, and the only thing that resolves most cases is a trial date. For the most part, a defendant will I mean, some of them will plea early, but if I mean, I'd start some days. I think the heaviest was start a trial day with 80 cases, and and these are people that had come in for a pretrial conference and said, "Oh no, I'm going to try. I want my trial. And then, you know, when they get there and you say, "Okay, it's your turn. We're going to ready to pick a jury." It's like, "Hold on a second, Judge. I think this is going to plea." And so when you cannot have trials, the same is true in civil. It just completely clogs up the system. Cases just don't get resolved because folks don't generally like to make a decision about something as big as that until they have a firm deadline when they absolutely have to make it. So, so we're working hard to get them started. Any other questions? Let's see. So the second question at 1238 was about the speedy trial. And we have a procedural speedy trial rule in Florida that says that you have to allow someone an opportunity to have a trial within about 6 months of the date that the charges from their arrest. It goes from their arrest. So you may have an arrest and then charges will file a month and a half later, and then you have 4.5 months to get the trial. Now, when things are working normally, I told you that defendants generally, in my experience, don't want to go to trial. And so what you'll get is, in almost every case, a waiver of speedy trial and a request to continue the case for more time to prepare. And so generally, the speedy trial right, the procedural right, if you want to call it that, gets waived. Now, the Sixth Amendment right, if you look at the case law interpreting the Sixth Amendment, it's not really geared toward any specific amount of time. What it says is that you cannot delay things so long that memories fade, and so it's sort of a prejudice thing. So you can't say, and certainly, I mean, there are cases where things were delayed and you know, years and years and years go by in the federal courts. I'm not familiar with the constitutional speedy trial case from the Florida Supreme Court, but there's some from the U.S. Supreme Court, and from the other appellate courts in the federal system said, no, that's not a constitutional speedy trial violation. So we aren't yet at a point in COVID-19 where I think we're probably not running up against a constitutional problem with speedy trial. But, and I don't know if I said this, but the Chief Justice suspended the procedural speedy trial period during the COVID, so it's not a procedural issue either. What is the prominent judicial philosophy of most members of the court? So, you know, judicial philosophy is an interesting topic. It's one that I actually enjoy talking about, but I think that most members of the court, well, you know, every jurist will say that under our system of government, that the courts are there to decide issues based on judgment alone and not to impose their will. So it's not our job to decide what the law should be and to change it. It's our job to decide and say what the law actually is. And so that, I mean, broadly, I think you won't find a jurist that doesn't say that that's their judicial philosophy. And that's what people expect. It's really interesting. And I think Elena Kagan said pretty famously not too long ago that we're all textualists and originalists now. In other words, so most judges have come to the point where they agree that if you're gonna interpret the law and not make the law, you gotta rely on what the words say of a statute if you're interpreting a statute, and you gotta ask, well, what did they mean at the time it was enacted? I mean, so I think I don't think there are any exceptions, although maybe, but the predominant view on the Florida Supreme Court is that legal text should be interpreted based on what the words say. So you don't go behind that to ask, well, did some legislator write an article saying we really meant something different, things like that. And it should be based on its original meaning. And that's the primary judicial philosophy. The way the media reports on everything that we do, if the result is one that, and I hate using these terms, liberal, conservative, but because they're really divisive, and we as humans are so much more complex than that. I mean, you know, we pigeonhole somebody as one or other, and our views generally are so, if you're a thinking person, I'm sure most of you are, so nuanced and so, and you may have a liberal view here and a conservative view here, or anyway, but I'll use those terms. But if the result is one that a liberal would like, they think that it's, you know, that's a liberal decision. If the result is one a conservative like, they think that that means you have a conservative judicial philosophy, because the result of that is a conservative result or a liberal result. And really, you know, I think all judges do the best that they can to really interpret the law and apply it objectively. So, okay, next one. Let's see. Go back. Can you put the pyramid back up?
Yes, 1 second.
And then does federal law, if somebody has a question about that, now I can't see the question. So.
What's your advice for people that want to be a judge in different states? Like you know, you kind of answer that question, but in law school, for people who are not in law school, like us, what would you say your advice is that you wish you knew before you became in law school or anything like that? Sorry if I'm interrupting people's questions.
Yeah, it wouldn't be any different, I think, than really apply yourself and do the best that you can. Because if you're if you're in a state where judges are elected, then it's sort of different, because the public doesn't tend to look back at your law school transcripts and things like that. But if it's an appointed position, then your academic record is important. So it's important that you just really truly apply yourself where you are, and really there's also no better rule than treating people well, and treating everybody with respect, whether you agree with them or disagree with them, because you know anecdotes are what can kill people, I think, in terms of you know, you're running for judge, or you're up for appointment, and the governor's office hears that, you know, you got into this nasty fight with opposing counsel and you were rude and all that kind. I mean, that something like that can really kill your chance, and you gain a reputation by the way, whether you treat people with respect or don't treat people with respect. So it's about I think the standards you set for yourself. If you set high standards for yourself and the way you perform in whatever you're doing, then people will want to promote you because you're doing what you do well. And if you do what you do well, that'll gain confidence, or people will gain confidence in your ability to do the other things that you're interested in doing well. So that would. Does federal law determine legality of cases you hear, or more emphasis is placed on Florida law? So we get both, and the rule is that if it's an issue of federal law, we are required to follow the decisions of the United States Supreme Court, and so that would be binding precedent. For example, for us, if we're determining a Sixth Amendment, Eighth Amendment, Second Amendment question, that would be absolutely binding, and we try to figure out, okay, what is the law based on what the U.S. Supreme Court said. That's not true of federal circuit courts, the appellate courts and the circuit system and the federal system. So if we're doing a federal question, those would be persuasive, but we could come up with a different answer than a federal circuit court. We could not come up legally with a different answer than the U.S. Supreme Court. We do get federal questions. Most of what we hear involves Florida law issues. And if it's a Florida law issue, we are the arbiter of that. So the United States Supreme Court, federal district court, is not going to say, no, Florida law is not what the Florida Supreme Court said. They're going to accept what we said in terms of interpretation of Florida law. We have a really interesting couple of wrinkles in the Florida Constitution. Generally, a state Supreme Court can give more, the way it's usually phrased is more protection when you're talking about the rights that are enumerated in our constitutions. In most states, Florida's like this, sort of copies or mirrors the Bill of Rights. So we have an Eighth Amendment equivalent and that kind of thing. And most states, and you will learn this in law school, can give more protection under their state constitution than the U.S. Supreme Court gives under the United States Constitution. Well, apparently the citizens of Florida got tired of that in several respects. And so they've added to the Florida Constitution several conformity clauses that say that we are required to interpret, and the Eighth Amendment is one of them. So the cruel and unusual punishment clauses, there are two in the Florida Constitution. We are required to interpret those like the U.S. Supreme Court interprets the Eighth Amendment, which means we can't give more protection under Florida law than the U.S. Supreme Court gives under the Eighth Amendment. And we have a couple of those in our Constitution. But if it doesn't involve one of those areas where the Constitution limits us, we can interpret our Constitution to give more protection than the federal law does. How do they decide who's up for retention? So after your initial term, which is 1 to 3 years, or a little over 1 year to 3 years, you go on the vote, and then after that, it's every 6 years you're up for retention. I saw the headline on the DACA opinion, and I generally don't comment on what the Supreme Court said. The question is, what are your thoughts on the Supreme Court's ruling on DACA? But I haven't even read it yet. I was in meetings all morning this morning. What's your favorite case to do research on since you're appointed to the Supreme Court? One of the things I love about the job is that you do get into any really complicated legal issue becomes interesting when you're trying to get it right. So you're trying to figure out what it is, you're trying to get it right, you're trying to do the best you can, and the more complex it is, the more you tend to dig in and really get interested in the issue. And so the last one I spent a fair amount of time on was I thought a pretty straightforward issue of, and the opinion's not out yet. It just went to final review today, but it's a pretty simple evidence. I loved evidence when I was in law school. We have at Florida State a professor who's in his 51st year of teaching evidence at Florida State University. And he wrote the book, literally. He helped write the Florida Evidence Code, but Earhart on Evidence is the book that, and it's Chuck Earhart's his name. He's on every judge's shelf. We all have Earhart on Evidence that we look at. And so I had evidence from him, but it was an evidence code. What do you have to do to lay a proper foundation under the business records exception to the hearsay rule? So that probably wouldn't mean much to any of you. It sounds boring, right? But I loved it. I dug into it. The hard cases that we get, and the ones that most of us don't really like working on, but it's such important work, are the death penalty cases. And those, I mean, they're the worst of the worst murders, and sometimes, that the standards of review require that you determine whether something would have made a difference or not. And because we have original jurisdiction in death penalty cases, we get the post-conviction stuff. So things like, well, the trial would have gone differently if my lawyer had done this, and a constitutionally effective lawyer would have done this. And so the first, under the U.S. Supreme Court case called Strickland, you ask, did the lawyer act in accordance with the basic standards for a lawyer? So were they ineffective or effective? And if would an effective lawyer have asked these questions in cross-examination? Would an effective lawyer have called this witness? Would an effective lawyer have discover this evidence and put it in, you know. So then if they did, you said, well, okay, so an effective lawyer would have done this. Would it have made a difference? Was there prejudice? And if so, the person gets another trial. And so, you know, every case that we have that gets affirmed on appeal, we have as a death penalty case at least one other time, and more than that really, when we have the post-conviction matter. And so when you're determining whether something would make a difference, how do you know unless you review like everything? For some cases, it's just, you don't have to review as much. So, and even though you don't like doing it because it's just not, anyway. But once I dig into a transcript and start reading everything that happened in trial, I really get into it, and you sort of get there. I mean, you know, having tried more than 100 cases as a felony judge, I can sort of see, it's almost like I'm in a movie. I'm reading and I can see what's going on with the witness and that kind of thing. So that really becomes interesting, even though it's probably our least favorite thing to do, and just if you asked. Long, all my answers are long, sorry about that. If I need to stop and you need to do the tour, just let me know. As a Florida Supreme Court Justice, do you spend more time doing research than circuit or county? Yes, absolutely. So as a trial judge, you know, you're in court most of the day, almost every day. And so you really have very little time for research. You can't, when someone makes an objection during trial, you can't say, okay, jury, we're going to take a recess. We're going to come back tomorrow because I need to research this. You've just got to say, sustained, overruled. You've got to rule and move on. And so as a trial judge, I did most of my research from the bench. I had the computer on the bench. I'm listening to the testimony. I'm listening to the questions. I'm going, okay, I'm about to get an objection on hearsay on this. And so I'm pulling up that part of the evidence code and sort of reviewing. And then we have, a lot of the problem areas in trials get repeated, right? So a good trial judge is going to have a bench book which has, you know, if this objection's made, what's the thumbnail for the law in that area? And it's almost like an airline pilot. You know, you want them to look at that checklist every time. You don't want them to get so confident that they just say, oh, I got this. And it's easy to do after you've tried a lot of cases. I mean, I'd try a lot of cases to just say, oh, I've got this. But so I really, and I learned this from a wonderful lawyer that I worked with when I was brand new, great federal prosecutor and then defense lawyer. But she, before every evidentiary hearing, she would like review the evidence code real quickly. And I was like, Jane, you've been doing this when I was a young associate in a law firm. Jane, you've been doing this for 20 something years and you've tried tons of cases. She said, I know, but you got to sharpen the axe if you're going to cut well. And so as I would just pull out that bench book when I would get to a question that, you know, so anyway, but very little time for research as a trial judge. And that really is a lot of what we do as an appellate judge. Do you think the rush to finish cases sends many innocent people to prison? You know, I think the answer is no, in part because we really don't rush to finish cases. I mean, when we're going to give the lawyers the time that they reasonably need to prepare for the case. So a lot of cases get continued over and over and over again. So if you're talking about the court system rushing to finish cases, you know, we don't rush generally to finish cases. Now, it sort of looks like it because of the volume of cases that we process. So if you come in and there are 100 cases on a pretrial conference and you're going like that through one to the other, you know, one to the next, it looks like you're rushing. But it takes very little time per case in order to determine whether this case is ready for trial or not. So, but there's no point at which we don't give the litigants the time in court that they say that they need to do what they need to do. So if that's where the question is coming from, I think, you know, rushed investigations that really don't look at everything. I mean, I see that argument a lot, that, you know, the law enforcement really sort of looked at this person early on and sort of didn't look again at this person. And so, you know, that in a lot of cases where the argument is that it was the wrong person, you see that. But so that's, is closed circuit television becoming more common as a result of COVID? And how does that affect someone's right to cross-examine? So, yeah, we're doing a lot. I mean, most of the hearings that happen in court happen without, they're not evidentiary hearings. So the question is, how does it affect the right to cross-examine? So that's not an issue. But in order to come back for things that were, like, one of the critical things that has kept going in Florida through COVID was domestic violence injunctions. And those are issued without a hearing, but then the person has a due process right to have a hearing very promptly after that. And those have been conducted over, just like we're doing this, over the internet, with Zoom in some places, Microsoft Teams and others. And so there are cross-examinations, and those, and the reports I'm getting from the trial courts is that really is going well. And in an injunction hearing, return hearing, the judge is the finder of fact. So, so far, that doesn't seem to have been an issue. And as I said earlier, as we move to jury trials, if we end up needing to do those remotely, that it certainly is a concern. What are the long-term effects of Corona on the court system? We have a massive backlog, and that's building because we can't have jury trials in both the civil and criminal context. So that's going to be a long-term effect. The one that you might not think about so much if you're not part of the system. So I said earlier, I'm the liaison of the Trial Court Budget Commission, and we've been, usually that group meets about once a quarter, and we've been meeting weekly. The executive committee is, and we've been trying to figure out where we can cut money, where we can save money, because state revenues are significantly down, and that's what funds the court system. So we're looking at, if the economy doesn't get back up, Florida has a balanced budget amendment in its constitution. So unlike the federal government, the state government in Florida doesn't spend money by borrowing. So if we don't have it, we can't spend it. And we're watching, we have part of our revenue, a lot of our salary budget, for example, comes through a state courts revenue trust fund that's governed by filing fees. And those are in civil cases. There are no criminal case filing fees. So with civil cases not really going forward, there are no foreclosures right now, which is good for the public. But one of the consequences is, you know, there aren't filing fees. And so, you know, we're looking really, I mean, we're not looking at furloughs yet, but we're about to put a hiring freeze in place for the state court system. And so it could, the revenue loss could have a dramatic effect on our ability to handle the cases if we get there. So that's the bigger effect. Let's see. Advice for a non-traditional student. Emily, are you trying to get my attention? Okay, can you let Emily speak there?
I was just looking at the chat questions.
Oh, okay.
Go ahead, Justice. Yeah. Okay.
What advice do you have for a non-traditional student who wants to apply for law school? Nancy's the right person to answer that question. And I'm sure you have, do you have sessions like that where you talk about, yeah, okay. So I don't know the answer to that. Do you have any interested or favorite books that you'd recommend to an undergraduate school student to attend before? I'll come back to that one because I'm going to think about that. Can you tell us about what a judge in the family courts have to deal with that's different from your daily duties? Yeah, so the family court, it's interesting, having been a trial judge, what the sort of the saying was that when you're in a felony division, when you're a criminal court, you see some of and this is not a kind way to say it, and I'm just going to say it the way it was said. You see some of society's worst people at their very best. And then in domestic court and in divorce court and child custody, you see some people who really, and I'll just say who generally play well with others and who are generally really good and nice people at their very worst. And so, and you would think that in felony court it would be really tense a lot but those cases generally are pretty smooth. The lawyers interact with one another well. The defendant is behaving. You know, you can set a really good environment, and you can try those cases and handle them without a lot of stress in the courtroom. But in the domestic divisions, the parties are so upset themselves and angry much of the time that gets really, really tense. And so they deal with a lot of stressors in the courtroom that I don't have to deal with when most of what I'm doing is research, reading, and writing. In the court that I do have, it's very, very controlled. It's lawyers, just lawyers, and the lawyers are generally acting appropriately. So that's one of the toughest divisions in the whole court system, is to have a domestic relations division for that. So do you think being a judge, do you think being a judge is one of the most effective ways to create change in the justice system? Yes, and I may have skipped one, but I'll go back. Yes and no. I mean, you know, a judge really is very limited as what we can't speak on political issues or public policy issues. Now, we can speak on administration of justice issues, but you know, we're just, the ethics rules that govern, and they do vary from state to state, but just don't allow you to say much in terms, and we don't set the policy for the state. It's the legislature that sets the policy for the state. So in that sense, no. But I can tell you that to have the biggest, and I tell our judges in the state this all the time, the biggest for the litigants that are in a community, for the people who are affected on a day-out basis by the court system and the justice system, the biggest factor in determining the quality of justice is the quality of the judge that's on the court. So if you have somebody that is that's not well prepared, that's slothful, that is not objective, that's biased, and that just, you know, doesn't really listen and just sort of shoots from the hip, then that is going to be a really bad result in terms of the court system. And so you being your best and doing the best that you can be, to be as fair as you can be, to treat everyone with respect, to really listen, then you can make the biggest difference to the litigants that are in front of you. So in that sense, there is no better place to be. But in terms of the broader overall policy things and everything that happens before something gets to court, then there's not as much we can do. What did I miss here? Considering the amount of wrongful convictions that have been found during the years, in your opinion, what can be the best way the court system can help reduce wrongful convictions? You know, that's a really good question. And I mean, in my role in charge of the court system, I think, and I determine, and I spend a lot of time in judicial education, that the thing that I'm responsible for, how I can do my part, is to help train judges to be really, really good, to have the courage to make the right decision when you're ruling on objections and that kind of thing. And I think it may be, I mean, judges are people, so I think it's hard for judges to sort of separate really at a deep level what people think of them and their decisions and the decisions that they're making. And you've got to do that to be objective and to be fair. You've got to not worry about how is this going to be viewed when you make the ruling and grant the judgment of acquittal that says the evidence is insufficient and this person goes free. I mean, that one of my good friends, he's now passed away, one of the judges that I served with always said that the primary quality to be a good judge is courage, because you have to be able to make what half the people that are in front of you and some people who may be politically powerful, a decision that does not make them happy. And you have to be willing to do that, ready to do that. And really, you do that best by not even worrying about what people think. And so to train judges to be that and do that and to be their best is the only thing I know I can do right now in that regard. And how many judges have to consider the money when it comes to making decisions?
I want to clarify that question, because so you say you're part of the commission about the filing fees and stuff like that. Do other judges have to think about that? I'm coming from the state of Vermont, so I just wanted to know, when it comes to like civil courts, filing discovery, different motions, do judges have to think about how many times people are filing a year? Is that something that you guys have to think about, or is that a different department or commission?
No,
Sorry, thanks.
Most judges don't think about that at all. That commission, the trial court budget commission, that's responsible for the money, and that's the court system works well, the administration, because we have judges that volunteered for those roles, and so that's in addition to their regular docket. Judges, a lot of them have additional responsibilities, and so that's an additional responsibility that only a few judges have and have to worry about. So, thank you. Throughout your law career, have you ever felt like your profession was boring, or were you mostly excited to be in the law? I've really enjoyed my career in the law. I can tell you that some people like the transactional stuff, like the working on deals, and find that exciting. I don't think I would, which is why I never went in that direction. But other than that, it's never been boring. The challenge that a lot of lawyers have and a lot of judges have is that it is a demanding career. And so, and technology in a lot of ways for lawyers has made it more demanding, because clients expect you to be available. And so the more clients you have, the better you are, the more clients you have, the more demands that you have on your time. And so the sort of the joy of it can be a little beat out of you if you don't develop and learn skills to deal with what could be stress from the high demands. But other than that, I've really enjoyed it. Can you be a judge and own your own practice? No, we are ethically prohibited from earning money any other way. So can't do that. You can teach. So there are a few judges that and they're Justice Polston, who's my colleague I talked about earlier, teaches a class at FSU as an adjunct. So so you can do that. And when I was first a trial judge, I taught Florida con law at night at one of the law schools in Orlando. But other than that, you can't have clients. And you're not allowed to give legal advice to folks, which makes my family and friends very frustrated with me. They say, I have this legal question. I'm like, nope, sorry, can't do it. Okay, I think that's about it. Okay, what is the most controversial ruling that you've had to make, or the most controversial case you've presided over? It's funny because we get the press clippings, and the Florida Supreme Court's in the press all the time, and somebody's unhappy with every decision we make, pretty much. So the question is, which side doesn't like it, and how loud they are. The most high-profile case I handled as a trial judge, I had a week-long evidentiary hearing in a shaken baby case. So the defendant was accused of killing his girlfriend, and they lived together. They were a couple. Her young son. and he was convicted. He'd been in prison for eight years, I think. And they brought a post-conviction motion, and it had multiple parts. So one part was that the local medical examiner in Orange County had been removed from office for incompetence, essentially. And it was this case, the autopsy in this case, that was the final straw. So he had, the young child that was killed was an organ donor, for example. And among other things, the autopsy detailed how each organ was removed. And when the medical examiner had the body, there were no organs. So I mean, so there was that issue. It was very high profile because of that. But interestingly, there were some international experts that came in and said that the death of the child was caused by vaccinations that the child had had the week before. And there's an international community of people that believe that vaccines are really problematic and bad. I mean, I know but it was the television cameras were in the courtroom every day, all day, for every part of that. And people were watching online from around the world because of the vaccine component, and and the local interest was because of the medical examiner. So, I mean, that's a lot of, I've sort of gotten used to it. Every time I'm in court now, it's broadcast online, but in the early 2000s, that was rare to be. You know, every move you made and everything you said was being broadcast around the world. I ended up setting aside the conviction based on the problems with the medical examiner without ever addressing the vaccine issues. And then immediately he pled to manslaughter for time served, and he was done that day. So that's how that case ended.
Is the title judge forever, or is it only when you're serving? Do you obtain that forever since you got elected?
Only when you're serving, yeah. I mean, a lot of people, so there are judges that will leave the bench and go back into practice, and they can't use the title judge then. If you just retire and are around lawyers who knew you when you were a judge, they may still call you judge or something, but it's a title for when you have the job. What is the one class that you would recommend that everyone takes in law school? I mean, you still have required classes, right, Nancy? I mean, so I mean, all the basics are required, and beyond that, I would say, pursue your interest. I mean, if you are gonna have a practice that has you in and out of court, then I don't know that it's required now, but evidence is key. That is your stock and trade. It's like a core thing, and it's a different way of thinking about things, particularly the hearsay rule. It's like a statistics class. You'll go, what? I don't understand that. What is hearsay? And so you need to spend some time with it until you get to the point where it sort of clicks and you can apply it quickly and easily to the evidence that you're considering using as a lawyer or that you're evaluating as a judge. How do you become a good legal researcher in writing? Any advice? So, yeah, like with anything, it's you do it a lot with the right feedback from the right person. So I know that at FSU they did when I was there, and I think they still do, a really excellent reading and research class. And what makes it so good is that you have a lot of assignments and you get instant feedback, and you sort of can apply that and get better as you go. If you end up going to a Florida law school, we have an externship program through the law school at the Florida Supreme Court, and it is the best training for research and writing, I think, probably anywhere, because the way we do it, we have a lot of people that ask us to hear cases saying that this is there is an express and direct conflict between this case from the 3rd district and this from the 1st district. And so that's an interesting issue. You have to figure out, well, what was the holding of this case? Is it really distinguishable, or is it really the same issue? And if it's the same issue, are they in conflict? And so we get thousands of those for, I mean, maybe thousands for every case that we end up taking, but a lot of them, there really is no conflict. And so we use our externs. They work on other things too, but they get those determination of jurisdiction matters, and the briefing is short, like 15 pages, I think, is the limit for a brief, whereas a death penalty brief is 100 pages long. It's a fairly discrete issue. And so you're writing a memo that's going to go to the entire court, all 7 justices, and one of the law clerks who's a really good reader is going to work with you, and so you're getting daily feedback. You'll go through a draft and another draft and another draft, and then as soon as you finish that one, you get a next one. And because you're doing a lot of cases really quickly, it stays really interesting. The issue is always whether there's a conflict, or we have other bases for jurisdiction. That's the most common one. But the issues involved in the case are really different, and you're having to look at, is this issue the same? So it really focuses and I think excels rapidly your analytical ability and your writing ability. So if you get a chance to do that, come join us, and the interns love the experience. So, okay, I think that's about it. I probably used all our time, right? Are we done? Well, I just, let me tell you, it is exciting being a lawyer. It's an exciting time, I think, in our country, in a country that tries to live by the rule of law and tries to really do justice for all. It takes really good people as lawyers to make that, and judges to make that a reality. And we've fallen short a lot in this country, and we have a long way to go. And that's why it's an exciting time to do this. So I know that this is a great program. I know you'll value from it. If you do end up at FSU, I look forward to meeting you at some point, and sure that I will. So I'm going to turn it over to you.
Thank you so much, Justice Lawson.
Thank you.
You're welcome.
Okay, so for those of you still on the line, if we still have time, we're good. I'd love to show everyone some features of our building. So here is the bench. Are we still on the line, Morgan?
Yeah, and if anybody needs to go and doesn't have time for a tour of the court, then you can go ahead and sign off now, but we're gonna go ahead and do the Supreme Court tour.
Is that the Supreme? Okay, thank you.
Yeah, so here's the bench. We have 7 justices. The Chief Justice always sits in the center. So our current Chief Justice is Charles Kennedy. That's a 2-year position. And essentially the Chief is voted by the other justices every 2 years. And when the Chief Justice takes office, or takes that position, they are basically controlling the entire judicial branch of government in Florida. So again, here is Charles Kennedy. This is his 2nd term as Chief Justice. His 1st term was back in 2010. And he's wrapping up his 2nd term, but was also reelected to serve another term, which will begin, actually, I think next month. Right, so next month he'll begin his 3rd term as Chief Justice. The closer you sit to the Chief Justice, the more seniority you have on this court. We have 2 nameplates that are missing at the 2 ends of the bench. So this seat is going to be filled by Justice Francis, and the seat on the end is going to be filled by Justice Curiel, who were recently appointed by Governor DeSantis just about a month ago. And Justice Lawson is from Orlando. Ricky Polston is another Florida State University College of Law alumnus. He also teaches some courses at the law school. He is from Tallahassee. Charles Kennedy, our Chief Justice, is from Lakeland, which is in Central Florida, between Tampa and Orlando. Justice LaBarga is from West Palm Beach. And Justice Muniz is also from Tallahassee. So we have 5 district courts of appeal. Going back to the graphic, I can plug that in one more time. And in the Constitution, we are required to have 1 justice who lives in each of the 5 districts. And then we have 2 at-large positions that can live anywhere within the state of Florida.
Is that unique only to Florida, or do you know if that's everywhere else?
It varies from state to state, but again, this is in our Constitution. We have the 5 district courts of appeal, and then we are required to have 1 justice from each of those areas here on this court. Okay, I wanted to give you a view of the podium. So right here is where the attorneys argue, and the 2 sides of the case. So we have the petitioners on this side, and then we have the respondents on this side. The attorneys are permitted 20 minutes per side to present their arguments right here at the podium. Okay. And also during that time, the justices are asking the attorneys questions about the case. So the case is about 40 minutes total. And then afterwards, this door right here behind the chief is where the justices will exit, and that door leads to their private conference room. Directly after the cases, they make immediate preliminary decisions on the cases that were just heard in the courtroom. But as Justice Lawson mentioned, it can take several months before the official decision is made public, and that is through the opinion. The opinions are released every Thursday at 11 o'clock. That's actually one of my jobs here at the court. So every Thursday, including today, I sent an email to all of the media in the state with the attachments. They're posted on our website, floridasupremecourt.org. And then we have a pretty large Twitter following. So we tweet that the new opinions have been posted. Okay, and feel free to jump in if you have a question at any moment. Here's the clerk's chair.
Where's the lady that types all the words up? I don't know what the official title name is.
Okay, well, that's a great question. So that is called a court reporter or a stenographer. And we actually don't use a court reporter at the Florida Supreme Court because I'm going to actually try to zoom in here. If you guys can see, can you all see that red light bulb near the ceiling? And if you can't, it's in that direction. But we have our own recording studio. So the Florida channel, WFSU, records all of our oral arguments. So since everything is recorded here and also hooks into our Facebook Live feed, we don't have to keep we have a digital record of each case. We don't have to have a transcript. So
and can anybody
go ahead.
Oh, sorry. Can anybody walk in there, or is there a limit, you know, how it looks like?
So the limit, and I'll show you where the public will sit. So we have 2 sides of the courtroom. All in all, we can hold 164 people inside this courtroom. It is open to the public, and it is available on a first-come, first-served basis. So once in a while, especially during the legislative session in the spring, we do fill up the courtroom, and we have several overflow areas that folks can sit down and watch the case live, either in the library or in the lawyer's lounge. But 164 is the limit.
Do you mind showing us a picture of the people on the wall?
Yeah, I was heading that direction.
Oh,
so
sorry.
we have had 91 justices in our court's history, going all the way back to 1846. So on this wall, these are the oil paintings of our more recently retired Supreme Court justices, especially over on this end. Okay. And then as we move closer to this area, it's in basically chronological order as we move from right to left. And then when we go to the lawyer's lounge in just a few minutes, I will show you our justices from the early to mid 1900s. I do want to point out to you all our very first female justice. This is Rosemary Marquette, who was appointed to this court in 1985. And we have had, well, now 5 female justices with the appointment of Justice Francis in our court's history. Okay, up here is our first justice of Hispanic descent. This is Raul Quintero, and he was appointed in 2002 to this court. And then I'm about to show you our first African-American justice, who's over on the other wall.
For the state of Florida, is that the only courtroom at the Supreme Court, or do they have two just in case something happens in that room?
That's a great question. We just have the one courtroom, so 164 people, and I don't know if Justice Lawson mentioned this, or I may have missed it, but we only have oral arguments in the courtroom the first week out of each month, and we don't have oral arguments in January or during the months of July or August. So most cases are really decided electronically. But this is Joseph Hatchett. He was appointed in 1975 to this court, and he is our first African-American justice on the court.
Can we review past recordings of the cases?
Yes, if you go to our website, floridasupremecourt.org, click on oral arguments. They are all available to you. They're archived going all the way back to the year 2000, including the election of 2000, Bush versus Gore. You can watch all of those recordings on there. We also have a YouTube channel, which is FL Courts on YouTube. You can watch them. Again, Facebook Live. You can probably find some archive videos on our Facebook Live if you like us on Facebook, and that's Florida Supreme Court on Facebook.
Do you know why they only hear, or you just mentioned that they only hear at certain times. Do you know why that is? Is that to give the justices time, or? You know?
That's just the protocol of the courts. Again, with most cases being decided electronically, the justices make a lot of their decisions in their offices or when they are working remotely out of their home office.
Gotcha. Thank you.
You're so welcome. Okay, does anyone have any other requests while we're still in the courtroom before we leave to go to some other areas?
Benches? Who sits in that bench? Is that an overflow? Or is
it is an overflow, especially when we have events and ceremonies. We will use this area, and then we also typically set up chairs in this area as well.
Where would does the media come at all? Or if they were to come, where would they be? Or do they not come?
That's a great question too. So still photographers right over here. So kind of next to, see that gate back here? Still photographers are permitted to take photos from this area. They're not allowed to take any video. They have to tap into our live recording to the studio so they can access the video feed that way. But still photographers are permitted.
Thank you.
Welcome. All right, so are we okay on time, Morgan?
I have one last question.
Sure.
With the civil, with the sorting of the cases of the previous recorded cases, is it sort of based on civil cases and criminal cases on the Florida Supreme Court website?
Are they sorted by civil and criminal, or do they include both, is what you're asking?
Yeah, I'm saying if it's sort of how would I know which recording is a civil case or a criminal case?
It's a little bit hard to tell. A lot of times the criminal cases will have someone's name versus the state of Florida. That's usually how I can identify them, but you'd have to really click in just to double check that information. But if you see blah, blah, blah case versus the state of Florida, that is usually a criminal case.
Okay, thank you.
You're welcome. Okay, so we're gonna move on to the Lawyer's Lounge. And on our way to the Lawyer's Lounge, you are going to see our justices from the 1800s. So we ran out of space in the courtroom, and the justices, our oldest justices, are housed in this hallway. So here we go, and I will show you our very first
Does
justice.
every judge get a photo when they retire? Is that something unique to Florida, or just judgeship?
Right, so every justice will receive an oil painting. They are hung inside the courtroom when the justice retires. So some of them have already been painted, like Justice Lawson. I'm going to show you his portrait in just a few minutes. His is hung in the lawyer's lounge and again will be transferred to the court when he leaves. So here is our very first justice from 1846. That was Thomas Douglas. Okay, heading to the lawyer's lounge now.
Are you by yourself now with COVID-19? Is it pretty empty? Oh, wait, are we off?
Okay, so this is the lawyer's lounge, and this is a room that serves several purposes. The first main purpose, I would say, is that it houses our current justices' oil paintings. So here, I'm going to try to zoom in. They're hung pretty high, but here is our Chief Justice Charles Kennedy's portrait. Here is Justice Polston. Here is Justice LaVarga, and then here is Justice Lawson. Okay, and the others have not been completed just yet. This room, another purpose of this room is used if we have a ceremony or an event in the courtroom and we exceed 164 people, then folks can come here. They can watch the ceremony on that television that I'm zooming in on right here. So they can sit here. Sometimes we have the new attorneys that are inducted to this court will actually sign their oath here in this room. It's also an area for attorneys to have coffee. We have a coffee maker over here. If they're waiting before their case is scheduled in the courtroom, they can come in here and check their emails and have coffee before they go into the courtroom. This room is open to the public though. Any questions?
Is it commonly used from your experience as for attorneys and stuff like that, or do you think the public use it often in your experience?
Well, about a year ago, we decided to keep it open every day to the public. So I would say it's mostly used by the public because when someone comes to our front door, the officers will point out all of our public areas, and this includes the lawyer's lounge here. So I would say it's mostly used by the public, but lawyers do use it quite a bit when we have oral arguments. And then again, if we have a ceremony and we exceed the capacity in the courtroom. Okay, so we're kind of working in a reverse order. This is actually the very first thing that you would see if you were coming for a tour. Okay, so you would come through these glass doors, you would get checked in by our security, and then you would immediately see the Supreme Court seal. I'm gonna try to get a close-up here. The Supreme Court seal is made of white bronze. At the top, in Latin, satsito si recte means soon enough if done correctly. The 18 stars represents Estrella, the daughter of the goddess of justice. Here is Lady Justice. And then the eagle represents freedom. Oh, and F for Florida right here. Okay, this room, we have 8 marble columns all around the rotunda space.
I have a question whenever you're done.
Sure.
Oh, I come from the state of Vermont, so our courtroom does not look as fancy. Is it because it's Tallahassee? I've never been to Florida either. Is it because it's Tallahassee and it's where all the major stuff happens in Florida? Is that why there's so much, it looks so glamorous?
You know, compared to other,
like this in Florida?
So compared to other states, our courtroom is actually not very fancy. It's kind of in the middle. So it's fancy enough so that you know that you're in an important place. But some of the Supreme Courts, including one that I visited last summer in Ohio, you know, it's lots of gold everywhere, and it was a lot more ornate than ours. But yes, you do, when you're here, when you open the courtroom doors, you do realize that you are in an important place. So again, I feel like it's fancy, but not over the top.
Definitely than Vermont, small state. But
right, right. Here is a sculpture made of copper. This is an eagle. Okay. And then I'm going to take you over to Our Lady Justice. So this would be on the way. This is the way you would take to enter the courtroom.
Who's the artist that paints the oil painting? Do they get to choose that? That's another question I forgot to ask you.
Yes, great question. So the justices select all of the, they make all the decisions about their paintings. So they select the artist, they select the frame, they select the style. You may have noticed that Justice Labarga has a suit instead of a robe. That was his decision. But yes, all of the decisions, including the artist, are left to the justice.
Great, thank you.
And here's, that's will be where you enter the courtroom. Okay, and lastly, I would like to take you all to the library. This is Florida's oldest state-funded library. It is open to law books or so that are housed in this library. If you do end up coming to the FSU Law School one day and you're looking for a quiet place to study, our library is another option for you all. It's always quiet here, and we'd love to have you study here. We're open Monday through Friday, 8 o'clock to 5 o'clock.
Wait, that library is included part of the courthouse?
Oh, wow. Yes, yes.
Definitely not like Vermont.
Yep, it's open to the public. We have legal research software that can be used. We have some computers over here. So pro se litigants, people representing themselves, really anyone coming in is welcome to use our computers. They can use the Westlaw research software for free. So here we go. And we have 4 floors in our library.
Is that funded by this courthouse?
It is. It's funded by the state, right? Yep. Okay. Any other questions about the library before we go to the rare book room?
I'm asking a lot of questions. I just want to know, where do people file, or do you not file? You just go in here, or, you know, like the clerk and stuff, the people you file petitions, or am I getting it wrong?
No, you're correct. So now if you want to make a filing in a case, you have to do it electronically. You didn't always just be that way though. You would have to come here in person and file, but we call it e-filing or electronic filing. So that is how we're still able to operate despite the pandemic because of the use of technology.
Great, thank you.
We do have a clerk's office though that has several employees. I think about 15. All right, so this is the rare book room, and you probably haven't noticed, but Eric Robinson, he's been with us during the whole tour taking photos. He is the archivist here at the court, and he can explain to you all the rare book room because he manages this room and all of the archives of our former justices. So Eric, I'm gonna go ahead and let you speak. Go ahead.
All right. Thank you all for coming to visit. I appreciate that. The rare book room holds the oldest and the most hard to find of law books. This is entirely a law collection, of course. There's no Harry Potter in here. The oldest of our law books goes back to 1597, which is considerably before our library. It's over there. in a look down case. If you want to walk with me over there, we can do that. Never mind. Right here is a Spanish law book printed in 1597 that goes through all the laws on the books in the Spanish Empire at that time. And we have it here for reference. There's not many people that can read Spanish that's that old. If you think about Shakespeare or the King James Bible and how that English sounds to us now, this is probably very similar to the way that Spanish would sound. And of course, it's a law book, so it's got lots of terminology that most people never come across. And right next to it is our youngest rare book, the oldest and the youngest together. And this is part of a trial transcript from 1946 and 47. It's part of the Nuremberg War Crimes Tribunal trials. And we have this here because our Justice Tom Sebring was appointed by President Truman to be one of the judges on the Nuremberg trials right after World War II. This is only one volume of 40 volumes of trial testimony.
Cool.
Neither of
Super
these
cool.
books, yes, they are cool. Neither of these books, and in fact, none of the books in this room are used a lot. That's another definition of rare. They're not used very often, but they are here because they contain important information about the law in the past. And they're not on Westlaw or any other legal database. You have to come to the library and pull the book off the shelf and read it. That's the only way to get access to that old information. And that's why we have them. So our justices do have access to that. Now, granted, they often will send their law clerks down to find the books and to read the relevant passages, but they use this material, and I appreciate that they have this to be able to use. Now, you might have seen these bookcases as we came in. These didn't start out as historic, but they're historic now. These are the bookcases that were bought for the court when we moved out of the Capitol building in 1913 and into our first Supreme Court building. And we've been using these ever since. Our 2M floor downstairs in the stacks is completely furnished with them. And so we're being very frugal with the taxpayers' money from 1913 to 2020 and going forward. That's a little bit of humor or lightheartedness, but these bookcases really are very useful, and they help to preserve the old books. You might see some, in fact, that have artistically creative book bindings. This is marbleized paper book binding. And there are a number of books, older books, not anymore, but older books that have various styles of that artistic mode. And that's just an extra added feature of it.
Do you see people going into the library often to better them, like to read their the law books, or do you see mostly used as like a study place, a place for people to gather their mind, or do you really see people trying to, you know, dig into the law?
I think the librarian could answer that better than I could, but from what I've seen, the people who work here in the building are the main users, and other people do come in on a regular basis, pro se and private attorneys and members of the public.
And, right, and sometimes students will study for the bar exam, for the LSAT using our library, but it's really open to anyone who
And because our library goes back to actually it goes back to the 1820s before we were an official library. This is a historic repository. We have archival material. For instance, the first minute book of the court that was that goes back to 1846, right after we became a state in 1845. So those historic resources are here as well in the library. I welcome you to come and visit when we are open to the public. You'll see lots of interesting things here, but you won't see Harry Potter, remember. All right, thank you very much.
Thank you, sir.
Okay, well, we're getting close to the end of the tour. Does anyone have any last minute questions?
Can you ask him real quickly, how do you become an archaeologist? What is that? What's his position? He said
he's an archivist, right?
Archivist,
so,
sorry.
They're asking about your
how
background.
Do you obtain that? How do you obtain a title like that? That sounds legit.
You go to college a lot. I got a master's degree in museum and archive studies, and I specialized in archive studies as well as studying museum. So
how
it's
did you go into the law? How did you?
Well, I didn't go into the law. I do this as a historian, and I bring a historical perspective to things rather than a legal perspective, because this building is full of lawyers, so they don't need more lawyers to handle the historical things. They need somebody with experience and training in historical matters, and that's what I have.
I like. Thank you.
You bet.
How long have you worked at the Florida Supreme Court?
Is that a question for Eric?
Yes, for Eric.
Go ahead, Eric.
I have worked here almost 15 years now.
Wow. That's awesome.
And before that, I worked at the Museum of Florida History, which is across the street in the R.A. Gray building, and dealt with all aspects of Florida history, especially Florida government history I was involved in.
Very
Thanks
cool.
for that question.
Absolutely.
Hi, Emily. This question's for you. I noticed online there was this public outreach internship. Is that still available with the COVID-19 situation for fall?
So yes, we normally do have an internship program, but it is on hold because we are not open to the public currently. But check back. We may open that back up in the spring or the summer.
Thank you so much.
You're welcome. Any other questions?
Thank you, Emily.
You're welcome. Well, if we're finished, if we don't have any other questions, I'm going to go ahead and pretend that you are actually here in our building, and I'm going to walk you out. And on the way out, you will see we have our police officers here at work. So here they are. This is where you would enter the building, and you would have to have all your belongings screened. You would have to provide your driver's license. You're not allowed to bring weapons of any kind, a lighter, cell phones when we have cases in the courtroom, umbrellas, or anything that could be considered or used as a weapon. So we have pretty strict security here. All right. Well, thank you all so much.
Thank you.
It's been a great hour and a half.
Thank you so much, Emily, and to Justice Lawson.
You're welcome.
Yeah, thank you, Morgan. Thank you, everybody.
Bye.
Bye, thank you.
You're welcome.